Hi guys, welcome to BTM Afrika. My name is NYDJ. Coming your way today is a very interesting conversation. We are going to break a bit of a complex issue and make it so easy so that every average Ghanaian or any ordinary person can actually understand. We are talking about the rights of an arrested person. Sometimes we get to hear that somebody has been arrested, the person has been put behind bars, and they are not being allowed to see a lawyer. Too many things get to happen. If you are arrested, do you have any rights? What are those rights? Where do you even get those rights from? These are things that are a matter of concern. And so we are going to break them down today on BTM Afrika. As I said, we are going to break complex legal issues and make it quite easy for you to understand. Well, my guest today is none other than somebody who has been my personal lecturer since I went through to KNUST Faculty of Law, through to the Ghana School of Law. And it's likely that if you've gone through the KNUST Faculty of Law, he's had an influence on you because he's taught you one way or the other. If you've gone through the Kumasi campus, that's the Ghana School of Law as well. He's taught you one way or the other. His name is lawyer Dennis Oppong Wiafe. He is with Obimbendu Law Firm in Kumasi. He is my guest on BTM Afrika today. Before we get into the conversation, let's take this quick break. We shall be right back. All right, so I told you my guest is lawyer Dennis Oppong Wiafe. Counsel, thank you very much for joining us on BTM Afrika today.
Thank you, NY.
Now, we are looking at an issue of rights, the rights of an arrested person. For a lot of people, once you are arrested, that's it. You are thrown behind bars. Nobody cares about you. There's nothing to do. What can you do? So, when we say an arrested person, who is even an arrested person, and what are these rights? Where do they get these rights from?
Okay, so NY, let me start from here so that your listeners will understand. We have two scope of laws. We have substantive law and we have procedural laws. Now, the substantive laws mostly impose obligation on persons. And it's these obligations that if you fail to comply with them, then one way or the other, you say you may have committed a criminal offense.
Okay.
Now, the laws that implement the substantive laws or are criminal laws is the Criminal Offences Procedure Act.
Okay.
Now, that Procedure Act gives the institutions, the courts, the police, YOKO, the law enforcement agencies, power. Since the law is also aware that the power which has given these institutions is likely to be abused, the Act 30 itself and the 1992 Constitution has provided rights for persons who may come into conflict with the law, who may violate the law, whom you may say they are accused persons, or who may be arrested by the police or any other law enforcement agencies.
Okay.
And it's important that these rights are provided because if rights are not there, these institutions will exert so much powers and they may abuse their powers as against the person who may have been arrested and who may want to be tried before a court.
Okay.
So the Act 30 and other laws, as well as the 1992 Constitution, has introduced rights for a suspect, right for an accused, and even right for a convict. So that the law enforcement agencies, the court, the prisons, the any other person or authority will not interfere with the enjoyment of certain rights that the law accords you, as well as your dignity.
So these rights are provided for by laws and statutes and all that. So
that is so. And even fundamentally in the 1992 Constitution.
So that we are looking at Chapter 5 of the 1992 Constitution.
That is so. And some of those rights are also in the Act 30. Which
when you say the Act 30, that is the Criminal
Offences Procedure Act. So we have the Criminal Offences Act, which mostly establish criminal offences. We have other laws as well that establish criminal offences. But what enforces the criminal offences is the Procedure Act.
The Procedure Act.
Which will give effect to the Criminal Offences Act.
Okay.
So it's in the Constitution and the Procedure Act that we have rights which protect a suspect, an accused, as well as a convict.
Interesting. So now we know what the rights are, as in where the rights emanate from.
Yes.
Now, what are some of these rights? Somebody has been arrested either in town or from their home, or they are on their way to work. They've just been arrested by a law enforcement agency. Are there rights for such an individual, and what are some of these rights? Okay,
so I'll discuss the rights of the persons in three categories.
Okay.
So I'll discuss right that relates to a suspect, that's at the time you have been arrested.
Okay.
Then I'll discuss, right, that relates to an accused person at the time you are being put before a court. And, right, that pertains to a convict after you have been convicted.
Okay.
By a court. So in respect of a suspect, a person who has been arrested, we have two forms of arrest. We have arrest where the police may invite you.
Yes.
And you voluntarily appear before the law enforcement agents, whether police, YOKO, or OSP. Then we have instances where the police will come and pick you.
Yes.
Where they may confine your person. Now, the first right that occurs the suspects at the time of arrest, if you are to even confine the person, is to inform the person the reason or the basis for his arrest.
Okay, so you need to inform the person the reason of his arrest.
Yes, immediately. But immediately depends on the surrounding circumstances. Would the person make it easy for him to be arrested, for him to be informed of the reason?
Okay.
Was the person absconding, running away at the time you were effecting the arrest? Was the person even caught in the act? Sometimes if we are caught in the act, they may try not to tell you why they are arresting
because you know what you are
doing. So sometimes they give some justification that you were not informed immediately because you were caught in the act. But whatever the situation is, you must be informed of the reason or the basis for your arrest.
For your arrest.
Another right that must be accorded the suspect at the time of the arrest is he must be informed that he has the right to remain silent.
Okay.
You don't have to say anything. After you have been informed of the reason of your arrest, you don't have to say anything that may incriminate you. It's your right. You may keep mute, you may keep silent. Another right that is accorded the suspect is the fact that you have the right to a lawyer of your choice.
A lawyer of your choice?
Yes, a lawyer of your choice. Mostly in Ghana, they don't inform the suspect. The suspect of that. They may take you to the police station. They may even take your statement where the person may say something on record, which may amount to confession before the person become aware that I'm even entitled.
Yeah.
Right, but you must be told of your right to a lawyer of your choice even before they
take that statement.
Yes,
interesting.
Even before they try to take that statement. Now, another right is you see the procedure for the arrest. Right, how they even effect the arrest. The law is that the law enforcement agents. I say law enforcement agents because people always think that it's the police. It's only the police that can arrest. Even the private individual can effect arrest without warrants. Yeah. So the person effecting the arrest may confine your person, right? But the law is that in that one is in Act 30, they shouldn't use unjustifiable or unnecessary force. So if a person is effecting an arrest, you have submitted to the arrest, even if they will put cuffs on your hand, that is fine. But if you have submitted to the arrest, they shouldn't use unnecessary or unreasonable force in effecting the arrest. When they do that, it makes the arrest unlawful. Now, the Act 30 has provided how the arrest should be done. If you don't comply with the statute, the arrest is unlawful. And if any unlawful arrest is effected, either by a law enforcement agency or an individual, I'll come to the individual, how the individual can effect arrest. If the arrest is unlawful, you, the one who were arrested, you are entitled to compensation.
Oh, because the arrest was unlawful.
You are entitled to compensation from the person. And in this respect, the person, if it's a law enforcement agent like the police, you can get compensation from the Ghana Police Service and in extension, the government. If it's a private individual, you can also get compensation
from that individual.
Person. Yes, it's in Article 19, Clause 5 of the Constitution.
I am interested in that particular thing, the compensation. Is it monetary or it could be something else?
No, generally, if you say compensation in this respect, it's monetary.
Oh, okay. And
it's monetary. So the law has provided the procedure for arrest.
Okay.
If the person effecting the arrest does not comply with the procedure, it makes the arrest unlawful. You understand that?
Yes.
And as I indicated, the private individual can effect arrest without warrants. Now, the interesting thing is that we have scope of offenses that a private individual can arrest without warrants. So if you go and arrest someone as a private individual and that offense doesn't fall within the scope, it makes the arrest unlawful. People don't know that. It makes the arrest unlawful.
They say citizen vigilante, so they can also just effect arrest.
No, it must go by the law. And you cannot say you didn't know the law because ignorance of the law is not an excuse. That's the interesting aspect of it. And there's another right that is accorded a suspect who has been arrested.
Okay.
And that is bail. I'll be very brief on that. So in the Constitution, if you have been restricted, arrested or detained, right, you must be sent to court within 48 hours. If you are not sent to court within 48 hours, you must be released. Now, the argument has been that Yoko has the power to arrest and grant bail, that OSP has the power to arrest and grant bail. If we read section 18 of Yoko's Act, they have the power of the police in respect of arrest. If we read section 28 of OSP's Act, it has the power to arrest, power of the police in respect of arrest. So what it means is that if Yoko has arrested you, it means that you are within the confines of being arrested, registered, or detained.
Yeah.
So what happens? If they are not taking you to court, they must grant you bail. That's why they seek to exercise their right of granting, because they cannot just let you go without certain conditions.
Yeah.
So when they release you, that's what they say, they have granted you bail. But it comes with conditions. So people say that why is Yoko granting bail? Why is Yoko? They have the statute that establishes their office has given them that power
to actually grant bail.
Not expressly, but to arrest. They have arrested you.
Yes.
Now you see, they do investigation.
Yeah.
So the investigation that they are conducting, they are not. They've never the finding yet that they can put you before a court. So what must they do? The constitution said you must be released, but the release could be conditional or unconditional. So it's a condition that bring in the bail.
Interesting.
You understand that? So the right of a suspect is quite interesting. Another right that is accorded the suspects, right, is even for the offense that you be charged with, right? At the time you did that act, that the law enforcement agents are saying it constitutes a criminal offense, that act should have been prohibited by a statute in force as a criminal offense.
Okay.
We call it principle of legality. So you cannot be charged for an act or omission, or you cannot be charged for a criminal offense based on an act or omission, which was not a criminal offense.
As at the time you were arrested?
As at the time you did the act.
Okay, as at the time you did the act.
Yes, so we have examples like, for example, if you breach a contract, it's not a criminal offense. So it means that if someone lost a complaint to the police that they had a contract with you, you breach that contract, the police shouldn't come and arrest you.
Oh.
Because you have not committed any criminal offense. You see, they are arresting you to enforce
somebody's contract, the contract you had with somebody.
Yes, but you see, the genuineness of an arrest should be in respect of enforcing. Don't forget, I started by saying that we have Act 29. Act 30 enforces Act 29.
Yes.
So they are coming to arrest you to make sure that they are enforcing the law. So if you have not violated the new law, why are they arresting you? So the arrest must be founded on an act or omission, which is an offense.
Yes.
Do you get the point I'm making? So you have a right, even for them to arrest and go further and charge you. The charge must be in respect of an act or omission, which is a criminal offense.
Okay.
So if today I'm doing something and it's not a criminal offense, but a law was passed tomorrow, I cannot be charged in respect of that law, because at the time that I did that act, it was not prohibited by any statute in force as being a criminal offense.
Okay,
So
I think that makes sense.
All these are rights of a suspect.
So we've spoken about rights of a suspect.
So this is just for a suspect.
So suspects even have rights, and that's quite a lot of them.
Yes. So after you have been arrested where you were a suspect, the law enforcement agency or the investigative department is done with the investigation. And then they believe that they want to charge you for a criminal offense, and you are being charged, and you are being put before a court. Then you become an accused person. The accused person too has rights.
Wow.
You understand? The accused person has rights. And the first right of an accused person, when you are put before a court, is that you are presumed innocent.
So the first right of an accused person put before a law court
is the presumption of innocence. You are presumed to be innocent until you plead guilty yourself, or until you are proven guilty. Now, this right is a right because it means that there is no burden on you generally to prove your innocence. The burden is rather on the prosecution to prove your guilt.
Okay.
You understand? So if you have been put before a court, you have right to remain silent. You have right not to say anything. You understand that point? You don't have any burden.
Okay.
In court, general, I'm saying generally because we have some exceptions. What you call news reversal rule and all that, where a statute to rather impose a burden on you, the accused person, to prove a fact. Other than that, the general rule is that the burden of proving the guilt of an accused person is on the prosecution. What it means is that the prosecution must produce evidence and persuade the court with the evidence beyond a reasonable doubt that you have committed a criminal offense. Except where your situation falls under the instances where, by law, you are supposed to prove a fact as an accused person. So you are presumed innocent.
Okay.
And even under the Constitution, you cannot be compelled to give evidence as an accused person. So there could be an instance where a person will be charged for a criminal offense. The person may not speak in court, but the person will be acquitted and discharged because the burden is on the prosecution. And after the prosecution closes its case, the court establishes that no prima facie case has been established against the accused. In that case, the accused will be acquitted and discharged, even though you've not spoken.
So, Lawyer Dennis, just for that ordinary Ghanaian who is listening to us and has no understanding of, these legal terms and prosecution, accused and all that, basically, yes, when you're arrested, you have rights as a suspect.
Yes.
Now, the police have been able to gather some evidence. They know that, okay, we can charge you for this particular crime. Now, when they charge you for that and they put you before court, you still have some rights.
Yes.
Those rights are, one of those rights is that you can remain silent.
Yeah, you are presumed innocent.
You are presumed innocent.
You don't have a burden generally.
So the prosecution, that's the one who has the case against you.
Who made the allegation against you.
That's perhaps the state.
Yes.
The prosecution will now have to prove beyond reasonable doubt that, yes, indeed, you've committed a particular crime.
That is so.
So if they are not able to prove that, it means you'll be let to go.
Yes. Even though, if you even had the side of your story, you have not put it up before the court.
So you can remain silent throughout the process.
That is so.
Wow.
But there are certain defenses that the law requires that before they even go to trial, you give the state information about it. For example, if you want to rely on alibi.
Yeah.
Right? You have to give particulars of same to the state for them to conduct investigation to ascertain the veracity of your alibi. So that if it's true, they will not even go to trial.
I'm sure somebody is like, alibi.
Your alibi is basically in a layman understanding where the alleged offense the act was alleged to have been done. You were not there. So you have alibi. You were not at the crime scene. Let me put it that way.
So let me make it simple. Like, they accuse you that you've stolen money.
Yes.
That maybe you stole money in the studios of YFM.
Yes.
At 10 a.m.
That is so.
And then your defense is that as at 10 a.m. I was in a meeting on that day. I was in a meeting at Bomso. So I was not there.
Yes.
So then you'd have to furnish the prosecution that information. So that they will do their cross-check to see that, yes, indeed, as at that time and that day you were not there.
Yes.
That is the defense of alibi.
Yeah. So if they establish, they confirm your claim that you were not there, then why do they waste its resources and put you before a court, waste time and all that?
It will be a waste of time.
Yeah. So that's an important instance. You have to give that information to the court. Sometimes, if you want to rely on insanity, you may have to raise it so that at your own instance you furnish the court or the state with medical reports, right? Because you have to, if they are able to establish a prima facie case, right? They have to also be preparing your defense. So if you want to rely on insanity, you need to get your medical report and all that intact. So that assuming the court established that, open your defense if you want to, because it's also a right.
Yes.
Don't forget, you may decide not to say anything. So to even give your defense is not compulsory. It's a right that you have.
Okay.
Right, to give your defense. So if you want to rely on insanity, then in that case you may have to prove that you were insane.
You were insane.
So they have to bring up that defense.
So sorry to cut in, but it means that one, you are presumed innocent, and that's a right you have. Again, you have the right to even remain silent during the procedure. Unless, of course, when it gets to, like you said, the honors reversal rule, you want to open a certain defense. That's when. So. Okay, so these are two rights of an accused person.
Yes, you also have the right not to even give evidence. So maybe you have been charged, two accused persons, right? You may be able to furnish the prosecution with information that may incriminate the other accused person, right? They cannot compel you. They can also compel you to even make a statement that will incriminate you. It's a privilege. That one is in the Evidence Act. You may claim privilege not to say anything that will incriminate you, right? So the state cannot compel you to give evidence. You may also have the right not to even speak, to say something that alone or in conformity with others, other statements or other facts will incriminate you. So that's a right of an accused person. The other right of accused persons, for example, now I forgot to mention this. One of the rights of a suspect is that when you have been arrested and you are in custody, you are entitled to facility to communicate with your lawyer. Sometimes they must even give you the right to make a phone call and all that. Ghana, they really allow that.
And I was about to ask because I mean,
they really allow
people
that.
normally complain that they are not even being allowed access to their lawyers. Their lawyers can't even find where they are being kept.
So they must give you facility to communicate with the outside world. If you want to call your family, if you want to call your lawyer, they must give you that right. If they deprive you of that right, it's a breach of one of your right to fair hearing and fair trial. So now let's go into the aside the rights or the presumption of innocence. During the trial itself, the trial properly, right?
That's when you are put before court.
Yes, and you have been arraigned. You must be informed of the charges which has been leveled against you in detail. You understand? It must be read to you and interpreted in a language that you understand.
Okay.
If you don't understand the language being spoken by the courts, you must be afforded an interpreter without any cost to you. So that one is being applicable. It's very obvious that I state by because every court you have interpreters.
Yeah.
So it must be interpreted to you in the language that. So if it's even in the Ashanti region or in the Eastern region, and you say, "Oh, you understand French," what the language you understand is French or Chinese or what have you. The state must provide you an interpreter who understands the language of the court and also understands your language, so that you have that form of communication.
So that's a right.
Yes.
What happens when the court realize that you are trying to abuse the process because they see that you say you speak French? Yes, maybe you speak French, but also te brofo kakra or te brofo. And at that moment, we can't really find somebody who speaks French and all that.
Okay, so sometimes where it works in two ways. If you're on bail, that's where you can play this devil advocate. You can do that. If you're on bail, because if you're on bail and they've not found the interpreter, it means that they have to still be looking for the one who understands your language.
And you still be enjoying some freedom.
Yes, but if you're not on bail and you go and say that you don't understand the language being spoken by the court, then they have to be looking for the person who understands your language. Sometimes they compromise. The accused person compromise. So, okay, you let this language flow, I'll try and understand.
Okay.
But if the person says that, is this language that I understand, you cannot proceed. Unless you get an interpreter to interpret to the person in the language that the person understands. Another right of an accused person is given adequate time to prepare his defense.
Okay.
Right. Give the person adequate time to prepare his defense. So there are instances where after the accused, the court establishes that prima facie case has been established against the accused. It means that you may either remain silent, be convicted, you may give an unsure statement from the dock, or you may choose to give your defense. Now, the court cannot say that bring your witness tomorrow or file your defense tomorrow, file your processes tomorrow, right? They must give you ample time to prepare your defense. You understand that?
Yeah.
They must also give you right to choose a lawyer of your choice, even at the trial. So there are instances where an accused person will go to court and tell the court that, my lord, I want to take a lawyer.
Okay.
Right? If he says, I want to take a lawyer, don't proceed.
It's incumbent on the judge not to proceed.
Right? It's one of the right, because he says, I want to take a lawyer and I can afford a lawyer. Give the person the opportunity to do so. Okay. If you are Jane and a person comes and he has not provided his lawyer, then you have given the right to choose a lawyer. You didn't exercise that right in good faith. So that way the court can proceed.
Okay.
But what the most of the time the judges do is that anytime an accused person says, I want to take a lawyer, and they are doing a procedure that is very important, the court will adjourn. The court will not proceed.
Just so they give you that room to be able to get yourself a lawyer.
A lawyer to come and defend you.
Okay.
Then you also have the right to also cross-examine prosecuting witnesses.
Prosecuting witnesses. Who are these individuals?
Okay, so the witnesses that the prosecution will call to testify for the state against you, the accused person, you have the right to cross-examine them either by yourself or by a lawyer.
Okay.
So if you don't have a lawyer, you can cross-examine them by yourself. If you have a lawyer, your lawyer too can also cross-examine. Okay. You also have the right to call witnesses when you decide to open your defense to also testify for you. So these are rights accorded and accused when doing the trial. And also you have the right to be tried in your presence. General rule, right? The trial must be in your presence. Except instances where you have been given the opportunity to be heard and you didn't come. You abscond. Maybe you were granted bail and you abscond. then you may be tried in absentia. Or your conduct make it impracticable for you to be tried in your presence. That way the court will remove you from the court and the trial will be proceeded with.
So that means basically you are in court, but you are making it quite uncomfortable for everybody. Proceedings can't really go on because of the action that you are putting up.
Yes, you can be removed from the court when you be tried in absentia.
Okay.
But the general rule is that it's a right for an accused person to be tried in his presence. The trial must be in the accused person's presence. The Constitution has provided only two exceptions that I mentioned. Either you didn't appear to be tried, or your conduct made it impracticable for you to be tried, even though you were in court. They will move from the courtroom and proceed. Okay. So these are rights that are accorded an accused person before conviction.
Before conviction.
You understand?
That means there could be something after conviction.
After conviction.
Okay.
So after the accused person has been convicted, what follows is sentencing.
So conviction is basically you go to
the court declares that you are guilty.
Okay.
The sentencing is the punishment that follows. You understand? Now, in respect of the conviction, there's an interesting law too there, which our courts have not clearly settled it because there seem to be divergent views on it. That at the time you have been convicted,
yes,
right? Even before your conviction, before I come to the sentence, before your conviction, there's a right there. Article 19, clause 11. For you to be convicted, at the time of your conviction, there must be a written law in force prescribing punishment for that conduct for which you are about to be convicted for that particular offense.
Okay.
So what it means is that at the time that you did the act, there was a law in force prohibiting your act. At the time that you are being tried, there's also a law in force which prohibited your act for which you were charged.
Yeah.
Now you are about to be convicted, but that law has been repealed. At the date of your conviction, that law has been repealed. Repealed means that it has been taken off from our books. As an offense. So the question is, can you be convicted or you shouldn't be convicted? Now, the Constitution says at the time of your conviction, there must be a written law in force. So there have been two cases because we are doing it normally. So I don't want to mention cases.
Yeah, sure.
But we had the case called British Airways and Attorney General, which says that until the law that repealed the offense has saved proceedings, which means the proceeding that was pending before the repeal, then they shouldn't convict you because there wouldn't be any law. Then we have Edmond Ando versus the Republic, which relied on Section 32 of the Interpretation Act and said that Section 34 of the Interpretation Act has saved certain we called saving clauses for repeals, effect of repeals. So that section is to the effect that if you have been charged for a particular offense and in respect of a particular law and the law has been repealed, the repeal will not affect proceedings that were pending before the repeal. It means that it should be continued to be convicted. Now, people are arguing that Section 34 of the Interpretation Act contravenes Article 19
of the Constitution.
So, as I said, we have divergent views.
And of course, the Constitution is superior.
It's a superior law, the supreme law. So, we have divergent views on this.
Okay.
But know that even before you be convicted, you have a right. That there must be a law in force before your conviction follows. Right. Now you have been convicted. You are about to be sentenced. At the time you are about to be sentenced, you have a right. You have it. We call it plea of clemency or mitigating factors. Right. So the court will let you know you have been convicted. You are about to be sentenced. What do you want to say? The plea of clemency or the mitigating factors are factors that the court will consider to give you a lower sentence other than the maximum in most cases.
Okay.
So that's where you see that the convict, he's no more an accused person.
Yes.
He's not a convict. The convict saying that I'm a first-time offender, I'm a young offender, I showed remorse, I even pleaded guilty, I saved the court time. Or even if he's stealing, the item that I stole, I have returned it. Right? So the court will consider all these factors to see whether to give you the minimum sentence, the minimum sentence, or give you the middle. Right? So we call it plea of clemency. It's a right that you have. So
I think recently the Chemawuntumi case, I think the judge considered that because they said he was a first-time offender. He has companies and he pays a lot of people and all that.
Taxes and all that.
So instead of the maximum 25 years,
he was given 20 years. So the court may consider all that as he's a right. He must be accorded that.
Okay.
Right.
So it means that the judge can also decide not to listen to those. You have the right to do it, but the judge can decide not to.
So what happens is that when you give those mitigating factors, the prosecution will rebut.
They may oppose it.
And also give the court factors that the court should consider to rather give you the maximum. So the court will assess the two.
Interesting.
Right? But in most cases where the state, that is the AG or the police prosecution, agrees with you, then in most cases the court consider the mitigating factors.
Okay.
You understand? So there's a right that a convict may have before sentencing. Another right the convict may have is that the court cannot impose a sentence more than what the statute imposes. So Article 19 clauses, you cannot impose a sentence more than what the law imposes. So the court has discretion to impose sentence, but discretion is to act within the statutory framework.
That's where I have this question. Sometimes you hear somebody has been sentenced to maybe 20 years for stealing or for whatever, and people are out there and say somebody steals a goat and they give the person maybe 3 years. Somebody has stolen the state money and they've given the person 1 year. People keep arguing about these things.
Okay.
Is that to suggest that, like what you said, there are sentencing guidelines which judges must go with, and they can't go out of that?
That is so. Okay, so we have in most cases, the offense creating section will give the punishment that from this range to that range. If the offense creating section does not impose punishment, we have section 296 of Act 30, the Procedure Act, which says that if the law that creates the offense does not prescribe punishment, the punishment should be this, should be that. So what happens is that we have certain offenses that does not have minimum. So it says it has maximum. So it could be a day to, let's say, 20 years, a day to 25 years. So if that happens, then the court must act within that sentencing regime. Now, the interesting thing is that some of the courts to criminal jurisdiction are determined by their sentencing powers. For example, if we take the district court, the district court cannot impose a sentence of more than 2 years.
Yeah.
So what it means is that if you commit stealing, right, the police exercise their discretion. Let's look at what you have stolen. Is it just maize? Is it cassava? Is it goats? Or is 50,000 Ghana cedis? Or 100,000 Ghana cedis? Or 1 million Ghana cedis? So that if you just go to a cassava, then they will take you to the district court. Because district court, the maximum punishment they can impose for under circumstance will be a term of imprisonment of 2 years. But when they look at the nature of the subject matter you've stolen, right, they may exercise their discretion to take you to the circuit court or the high court. So when they take you to the circuit court or the high court, they don't have any limitation in respect of the sentence aside what the statute says. So they can give you the maximum of 20 years.
So sometimes you need to be pleading with the police.
Sometimes they may exercise some discretion there to take you to the district court. But we have certain offenses that have minimum sentence, like robbery. Robbery with offensive weapon is not less than 15 years. Robbery without offensive weapon is not less than 10 years. So that one, the court cannot go below. So they cannot take robbery to district court because district court cannot impose a sentence of 10 or 15
years. The maximum they have is 2 years.
So they have to take you to either circuit court or the high court. And when you go there, as I said, the court must act within a sentencing regime.
Okay.
So the court cannot come below. The court can also go below. But robbery does not have any maximum. So the court can give you 100 years for robbery.
Okay.
It rather has minimum. So where it does not have a maximum sentence, then you are dead.
Because I've heard cases where they say that there was a judge in one of the high courts in Kumasi. At some point in time, armed robbery became a big thing, very rampant. And so once they took you to his court and they were able to, you are convicted, it means you are in trouble.
Yes,
they could sentence you to 80 years.
Because there is no maximum.
Yes.
And he's acting within his sentencing regime or jurisdiction. Right. Where it also gets interesting is that the Constitution requires the court to take into account the period the accused then spent into lawful custody before the sentence.
Okay.
So what it means is that, assuming during the trial you were remanded during the trial and you were in custody for about 2 years, right? So, for example, offense like stealing, which does not have minimum, and is being tried by the circuit court. Maybe the circuit court wanted to give you 3 years in the judge's mind, but if you already spent 2 years in lawful custody, the court can say go and spend 1 year.
Okay,
you understand that. But if the offense has minimum, like say 15 years robbery with offensive weapon, you've already spent 15 years in custody. Before your conviction, the court cannot give you any period less than the 15 years. Even though you have already spent 15 years in custody, the judge will take that into account. But there's nothing the court can do about the minimum sentence.
So he still has to give you 15.
Or even more if he or she wants.
Wow.
Because section 315 of Act 30, the Criminal Offence Procedure Act, is to the effect that sentencing does not take retrospective effect. What it means is that if the sentence is imposed, it takes effect from the date it was imposed.
So whatever you might have spent in prison, in custody or in remand, would not really matter.
Yes, it mostly matters where there's no minimum sentence. Or the minimum sentence is lower than what you spent in custody. So if it's like stealing where we don't have minimum sentence, but we rather have maximum. If you have already spent 2 years in custody, the court may take that into account in imposing your sentence.
Okay.
But assuming the offense, the punishment is a maximum of 2 years, you've also spent 2 years in custody. The court may say that, okay, it's maximum of 2 years. There's no minimum. If you spend 2 years, I'll give you 1 day.
Yeah.
But it has minimum of, let's say, 2 years. You've already spent 2 years. Because it has minimum, the cost cannot come below the minimum.
So we cannot say you've served it already, so go.
No. Because it does not take retrospective effect. It must run from the date that it was imposed. That's a sad aspect of that. Right?
Interesting.
In respect of the sentencing regime.
All right, guys. So we're still talking about rights. And of course, we've had rights of a suspect, right of an accused, right of a convict. And of course, I'm sure there is more.
Yes. So even in respect of the sentencing, we have sentences that run concurrently and sentences that run consecutively.
Yeah.
Now, in respect of, for example, Untumi's case, some people were saying that, why didn't they put all the charges together as one? So he had cases in different courts.
Of course.
For different.
There's the samurai boy one, there's the exit bag, there's another.
So the interesting thing is that they couldn't have done that genuinely because they are different set of facts. Different isolated incidents.
Yeah.
Right? So they are justified in putting you in different courts. Right? If it's were one set of facts like the one that he was convicted, it has to do with this one set of facts, but different charges, different counts. They can put you before one court. Now, the offenses may have different punishments. The offense may have different punishments. So maybe one will say one count 10 years, another count 15 years, another count 20 years. Now, because they arise from the same set of facts, the court will say that the sentence should run concurrently. What it means is that all the smaller sentencing will subsume into the bigger one. So you serve the maximum sentence that was imposed.
So maybe count 1 could lead you to 10 years.
Count 2
could lead you to 15 years. Count 3 could lead you to 20 years.
Because it arrives from the same set of facts, the court mostly or most likely will say that it should run
concurrently.
So that you serve the maximum.
So in this case, it will be the 20 years.
The 20 years.
Okay.
You wouldn't spend 10 years, then after the 10 years, 15, another 15, the 25. So sorry, the 20.
The 20.
But in most cases where the acts or the count arise, if there are instances where they can put it together, right, in one charge sheet, right. But if they arise from different sets of facts with different victims, different implication, the court can say to run consecutively. What it means is that you serve this,
then you come and serve the other
one.
Into you are near say
yes.
They will go to be another prison.
Yes, but there's a provision in Act 30 in respect of, for example, to cases where they are different in different courts, which allows that when you have been convicted and sentenced, right, you can apply to the court for the court to consolidate, put
all the cases,
those sentences together, so that if the court deems it fit, the court will say the sentence should run concurrently.
Okay.
There is a provision like that
in the Act.
So these are all right. That one or the other is accorded a convict. Another right of a convict is right to appeal.
We hear that a lot. Chairman to me is appealing the sentence.
So maybe the trial judge might have erred. Sorry, beg your pardon. So you have the right to appeal. Constitution has a right to appeal, so that an appellate court will hear the matter and establish whether something went wrong, and if we are acquitted and discharged, There are instances where someone will appeal against only the conviction and sentence. Some man may also appeal against only the sentencing. So the person may not have problem with the conviction, but let's say the person says, "Oh, I pleaded mitigating factors, clemency and all that." The surrounding circumstances then warrants imposing that
maximum sentence
because it's so harsh based on the circumstances. So the person may appeal only against the sentence and leave the conviction.
So it means that this person who's been convicted agrees that yes, of course, the offense was committed, the crime was committed, but the punishment that you are giving to me is too much.
Yes, so the appellate court should reduce it.
Okay.
You understand that? Now, when the person appeals, the person has another right there. That is to apply for bail. So you also have bail pending appeal.
Okay.
So that during the hearing of the appeal, your liberty will be protected. Right? And we have grounds. It's not automatic. The court exercise discretion there. So you must justify why the court should grant you bail pending appeal. They have grounds that you have to establish. So it's not automatic. You must have exceptional grounds for the application being made. It must be clear on the face of your appeal that the conviction or the sentence is wrong. Your conviction must be in such a way that, or the offense must be in such a way that you need time to confer with your lawyer for you to be granted, for you to be able to prepare
enough for the appeal.
Or by the nature of the sentence, right? If we are to allow you to be in custody pending the appeal, then before the appeal is even heard, you might have finished serving the sentence. Because of, let's say, the time that they might use to prepare the record of appeal or legal vacation. So now, judges are on vacation from August to September. Right? And the court gave you 4 months.
By the time the judges are back, you might have spent all the time in jail already.
The 2 months or the 4 months in custody. So in that case, the court may consider and grant you bail pending appeal.
So there are conditions that must be met.
Yes. Now, if your conviction and sentence is set aside, and you might have spent some time in custody, either if you have spent the whole period of your sentence or a part of it in custody, you are entitled to compensation.
The compensation part, it's
very interesting. So a person who has spent whole or a part of his sentence and his sentence and conviction is set aside on appeal is entitled to compensation. It's provided in the Constitution, Article 14, Clause 6.
So that's also a right.
It's a right. So you can apply to the Supreme Court for a compensation to be awarded you.
But they get to determine how much you should be.
Yes.
Based on...
This right is really exercised in Ghana.
I think until recently, I saw a story that had been posted by, is it Super Law GH or something? They narrated an incident of somebody who had been kept in prison for a number of years. And now the person went back, the conviction, everything was set aside. And so the state attorney general, he was asking for a certain amount of money. The attorney general's office felt like he didn't deserve that amount of money because he couldn't prove how much he could have been making if he was still doing his normal work.
Your loss of earnings.
Exactly.
But you get something because of your right that was curtailed, your reputation, the stigmatization and all that. So you get compensation.
So that's a right for...
Yes.
Okay.
So these are the right that are accorded suspects, an accused and a convict throughout the criminal proceeding. Basically, in brief.
Interesting.
Then I forgot to also mention, even an accused person has right to bail.
Once you've been accused?
Yes, at a pending trial. So you see, we have bail pending investigation. We call it police inquiry bail, which can be granted by any law enforcement agents, being YOCO, the police, or the OSP. Then we have bail pending trial. Then we have bail pending appeal. They are all right. That's accorded, or that are accorded persons who come into conflict with the law or who faces the criminal justice delivery system
in Ghana.
Interesting,
guys. So this, I'm pretty sure, has opened you up to how the process works, the rights that you have as a suspect. I mean, it could happen to anybody. You could just be bundled up in a situation that somebody might say you are involved in whatever. So the rights of an arrested person, the rights of an accused person, the rights of a convicted person, all these rights do exist for you. And that's why lawyers are very important. You need to make sure you have a lawyer. Talk to them in cases like this so that they know how to deal with it and make sure that you get your liberty. When
a quick advice I want to give is that if you have been summoned by the police, don't write your statements until you get to a lawyer. You get advised by a lawyer, you are presented by a lawyer. Because people don't know that you may say something on record when they are taking your statements, and may amount to confession or admission of the crime that you may not know. So the lawyer will not coach you, but the lawyer will advise you as to how you make your statement. That will not amount to confession. Because you may think that, so someone, you are charging for murder, you've killed someone. Say, oh yes, I've killed the person. But there may be instances that cause that. So the lawyer wouldn't tell you that go and say I've killed the person. But the lawyer will guide you as to how you put your statement across, not to amount to automatic conversion, but may suggest that you have some form of defense. There are instances where you may write your statement, but your statement will omit the part that you have a defense. So there are instances where you may confess and avoid. So you may admit, but you make statement to the police that shows that you have affirmative defense that will exonerate you completely.
That could perhaps be.
So my advice to the general public is that take a lawyer, right? Call for a lawyer. It can be from, if you don't even have money, you can call to the legal aid. They will come to us. Before you make a statement to the police, for them to record as your statement to the police, always consult a lawyer. People take their statements. Then at the time they are being arraigned before the court, then they call a lawyer for bail. They call a lawyer for bail.
And it might be too late. You've taken a particular statement that they can rely on.
And you cannot say, unless your statement was obtained by coercion or it breaches the requirement of taking a statement. Right? If it goes into evidence, it has a grievous effect on you. And if you want to make further statement, your further statement cannot be inconsistent with what you said.
You've made already.
That it may even affect your credibility. So my advice is that before you give any statement to any law enforcement agent, make sure your lawyer is present.
Okay.
Or if your lawyer is not even present, talk to your lawyer. Tell the lawyer what happened. So your lawyer can advise you as to how you make your statements.
Interesting. So you've heard that. Make lawyer friends.
Very well. It's very important.
Very necessary. Make lawyer friends. Talk to them on some of these things. Get the advice and make sure you do the right thing. My guest today on BTM Afrika has been none other than lawyer Dennis Oppong Wiafe with Obey Menu Law Firm. He's taking us through it's a whole lecture, and I just hope that you would understand this so that you protect yourself and you guide yourself as you go along. Don't fall into conflict with the law. Don't fall prey to any of these things, but make sure that you are always guided when it has to deal with your rights. So the rights of a suspect, right of an accused, right of a convicted person, all here on BTM Afrika. If you've got anything to share with us, just make sure that you leave your comments and we will give you the feedback as and when necessary. Thank you very much for watching BTM Afrika. My name is NYDJ. Like I said, my guest was lawyer Dennis Oppong Wiafe. We shall be back with another episode here on the same show. Thank you.
Tabani music.